Chapter 1 deals with the regulation of lawyers. In Pennsylvania, the regulation of lawyers, and that involves setting the requirements for admission to the bar exam, the scores that you must achieve on the bar exam in order to be licensed to practice law in the state, any disciplinary action taken, anything related to that regarding lawyers is under the purview of the Pennsylvania Supreme Court, which is typical in most states, if not every state. It is the Supreme Court or the highest court of that state that is responsible for the regulation of attorneys. What Pennsylvania has done and what most states have done is they've created an organization to deal specifically with the disciplinary aspect um, of of attorneys. In Pennsylvania, you can find this information at the website listed there, pennsylvaniadisciplinaryboard.org. This is a good website to be familiar with, just from a practical and professional standpoint. You can look up any attorney that's licensed in Pennsylvania, see if they're in good standing, see if they have any disciplinary action taken against them. You can find the rules of professional conduct on that website. You can find the complaint form to fill out and how to submit the disciplinary complaint for an attorney. So there's a lot of good information there. So you should be familiar with that website. So that's the PennsylvaniaDisciplinaryBoard.org website. The Supreme Court has created the disciplinary board, as I mentioned, but the Supreme Court still maintains exclusive jurisdiction over all matters of attorney discipline. The disciplinary board was formed in order to issue rules, was formed in order to deal with very specific issues. But the Supreme Court does still have authority over the disciplinary board. You can go to the website and you can certainly find out a lot more detail about the organization. You do not need to know all of that for purposes of this class. What we're going to focus on is that it's the different types of sanctions that can occur. Now, to get to a point where a sanction is issued against an attorney, you first need to have somebody file a disciplinary complaint against the attorney. And as I mentioned, this information can be found at the website. And it is very consumer friendly, but information has to be provided. It goes to the disciplinary board. It is then reviewed to see if an ethical violation may have actually occurred. I would imagine, like a lot of complaint processes, that sometimes people file complaints because they're unhappy with the results of their case or with something the attorney did, but the attorney may not have actually engaged in any sort of professional misconduct. If it appears that there was actually a violation, then there is a process that it goes through, up to and through a disciplinary hearing held at this board level. These decisions, if the attorney is unhappy with those decisions at the board level, then these cases go straight to the Pennsylvania Supreme Court. They do not go into trial court. Since the Supreme Court oversees all attorney disciplinary issues, these cases go directly to the Pennsylvania Supreme Court. So the different types of attorney discipline, and if you are interested in more details, there are rules of disciplinary enforcement. Rule 204 is where this information can be found. Now, there's some types of discipline that can be imposed only by the Supreme Court. So these would be cases that are either heard before the Supreme Court, or there is a settlement, so to speak, that the Supreme Court then approves of. The most serious is disbarment. Typically, disbarment means the lawyer loses their license and cannot practice law anymore in a particular state. In Pennsylvania, I think this is a little unique. It is possible that when the disbarment sanction is given, that the attorney may be informed that if they meet certain conditions, they can re-earn, so to speak, their law license. So, this is not in every situation. So you still have to assume disbarment. Attorney has lost their license, but there may be those cases where the Supreme Court or the disciplinary board has determined that if certain criteria are met after a certain amount of time, the party may be able to to regain their law license, but that is not going to be the typical situation. The second most serious is suspension not exceeding 5 years, so suspension up to 5 years. And again, during that time of suspension, attorney cannot be practicing law in any way, shape, or form. There are plenty of cases out there where attorneys have been suspended and still are actually engaging in the practice of law in some way, shape, or form, which usually means that they end up being disbarred after that. Public censure with or without probation, which is basically a serious reprimand, and probation under the supervision of the board. And so that would be like any typical probation situation where certain criteria must be met in order for the attorney to be removed from probation. And usually that probation comes with a specific time frame in which the improvements must be made. So all of these are types of discipline that are imposed by the Pennsylvania Supreme Court. The other types of discipline, and these have changed a little bit in the past couple years, public reprimand with or without probation. And again, public just means it. You can look this up. So anytime you see a public reprimand, public censure, if you go to the Pennsylvania Disciplinary Board website, you look up an attorney, that information would be visible and you could see what the discipline is. Private reprimand by the board, private informal admonition by disciplinary counsel. And so those are the less of all the sanctions. This remains private. It is not something that we could access through the disciplinary website, but all sanctions become part of the attorney's file with the Supreme Court. And so even though the public may not be able to see it, the disciplinary board and the Supreme Court would know that these sanctions have been issued against an attorney. One of the big questions that I tend to get is what happens if an attorney is disbarred in one state? Are they automatically disbarred in every other state that they practice in if they are in fact licensed in more than one state? The big answer to that is it depends. You would have to go to each state and see what their disciplinary rules specifically state. The ones that I have seen, it does state that if you are disbarred in one state, you must notify the other state where you have a law license, and usually they end up being disbarred in that state as well. But that you would have to look at their specific rules to see what the criteria is. It is usually incumbent on the attorney to report what states they are legally licensed in and if they have faced any disciplinary action in any of the other states where they might be licensed. So we can't say across the board they would automatically be disbarred in every other state, but it certainly would be a very strong likelihood that that would occur. Those are the types of attorney discipline. The rules of professional conduct. So these are the rules that we're going to be focusing on this semester. You have the link to these rules in D2L. You can also buy a small booklet of these rules from the Pennsylvania Disciplinary Board. You can go to their website. It's $5 for one person, and if you go in on it with someone else, it's a little bit cheaper per person. These are the ones that you'll see me using in class. The rules of professional conduct have been adopted by Pennsylvania, and they are based on the ABA model guidelines for professional conduct, and every state has a similar version. In order to be licensed in any state, the attorneys have to pass a bar exam, but they also have to pass an ethics exam, and there's only 3 states that do not require the same specific exam, and all that means is that they have their own exam instead of using this multi-state professional one. And these are the minimum ethical standards that attorneys must follow, and we'll be talking about this a lot as we go through the next couple months of this course, is always keeping in mind that ethical standards are the floor, they are the starting point, they're not the end point. Rules, especially ethical rules, but any rules, any law cannot address absolutely every single situation. So the goal is to not try to find a way around the rules, but trying to ensure that our conduct is always compatible with the rules. Okay. As attorneys, as the licensed member, they're always going to be the ones that face potential disciplinary action when the rules are violated. However, should a paralegal or someone who works for that attorney violate the rule, the paralegal or the employee will not necessarily face disciplinary action because they're not the ones licensed, but the attorney will be. And so it is important that everybody who works for the attorney understands the rules so we can ensure primarily that we're providing the best service to our clients, but also to ensure that we're not facing or causing our attorney to face any potential ethical violation and disciplinary actions. There is a site in the materials that gives you the advisory opinions. This is a place where advisory opinions can be located. It's also a place where people can submit the situations and ask for an opinion. These are not binding, but they can be helpful sometimes in figuring out. So if you were ever looking up a situation for an attorney dealing with what is appropriate under the rules, remember that this website is out there and that you can look up some of these opinions. You may see something that assists you in figuring out or helping your attorney figure out what to do in a particular type of situation. Another thing to keep in mind is that the fact that attorneys can face other possible actions outside of the disciplinary enforcement procedure. Obviously, criminal charges can be filed if a crime has been committed. This frequently occurs when there is a commingling of funds. And the commingling of funds is when the attorney basically takes money that they're holding on behalf of a client usually in their retainer accounts, their client retainer agreement, or I'm sorry, their client retainer accounts or escrow accounts, and uses that for improper purposes, other firm purposes or personal purposes. That is the commingling of funds. A lot of attorneys get into trouble for this, and criminal charges have been filed on attorneys that have commingled funds. I know of a case where an attorney, it was actually federal charges were filed against him, and it was mail fraud. That's what they actually charged him on, and it was commingling of funds. So there's crimes out there that certainly can be applicable to the situation. There's also the civil case. Most common one would be the legal malpractice. Legal malpractice cases are very difficult to win on because they are challenging. And, the first couple things you need to prove are pretty easy, that you in fact had a client retainer agreement. So, you're going to have paperwork, your client's going to have paperwork. So to prove the existence of that relationship is pretty easy. But then you have to prove either breach of contract or negligence. And you have to prove that in fact caused the client not to succeed on his or her underlying claim or defense. So you have to prove that breach of contract or that negligence, whatever the attorney did or failed to do, that is what actually caused the client to lose that underlying case. That's a very high burden for a client because, as you know, and as we've talked about in other classes, there's a lot of variables that go into the success of a case. And sometimes it's our client that is the biggest risk factor in our cases or the biggest detriment to the case. It's not always what the attorney does. And just because a claim or defense is unsuccessful does not mean that there was any sort of legal malpractice. So these can be very challenging cases, and it can be very challenging for clients to find attorneys to take these cases. And they can get very frustrated because they feel like they're being shut out intentionally. And that's not the case. It's just that these are very difficult cases to win because of all the variables that go into it. But that is what a party would need to prove in order to win on legal malpractice. Also be possible to file monetary claims to recover monetary damages. So if they are out money based on what the attorney did, they may be able to bring a claim. And some of the cases we're going to look at this semester are examples of those types of cases, especially where the attorney has already been sanctioned or disciplined for failing to do what they should have done. The client could then file a monetary claim as well. So those are just some of the options regarding the sanctions and how they are handled in Pennsylvania.